So welcome everyone. My name is Leah and I'm the Knowledge Exchange Manager here at Women's Shelters Canada. I'm going to be moderating our webinar today and I'm really looking forward to it. There's lots of great information we're going to go through with our speaker today, who I'll introduce in just a second. I just want to start first, of course, by acknowledging that I'm joining you today from the traditional unceded territories of the Algonquin and Anishinaabe people in Ottawa here. We're based in Ottawa, our work is on this territory, but we do work across the country. And I know with this virtual setting, there's folks who've joined us from across Turtle Island. So please do feel free to say hi in the chat, let us know where you're joining us from, and yeah, just say hi. And if you don't know what territory you're on, this is a gentle reminder to find out a little bit more, to learn a little bit more about the history, the current context of the land you're on, and the people. So I have gone through the interpretation and the closed captioning. If you have any technical questions, anything's not working for you while we go through the webinar today, just let us know in the chat and my colleague or I will do our best to help you out. You probably have noticed that you are muted, your video is off. We have quite a few people on today's webinar, so we are going to have only the panelists with their video and audio on, but that doesn't mean we don't want your participation. We definitely do. So there's a few ways you can do that. You can use the chat at the bottom of your screen to make a comment. If you have a technical question about Zoom, or if you want to introduce yourself, feel free to do that in the chat. If you have a question for our speaker, please put that in the Q&A box. That makes it a lot easier for us to keep track of all of the questions if they're in the Q&A rather than in the chat with all the other messages. And so we will pause a few times for questions throughout. We'll answer questions at the end. So please don't hesitate when you have a question to put it in there. And just so everyone knows, we are recording today's webinar. I will be sharing a link to the recording next week sometime once it's available, and also a copy of today's slides. So without further ado, I will get us going into our topic here. As you know, today we have Pamela Cross here with us to talk about parenting challenges for women with abusive ex-partners under the new Divorce Act. And this is part one of a two-part series. We're very lucky to have Pamela joining us twice in the next few months. So today we're focusing on relocation of children, decision-making for kids. And then in January, we'll have another session, and that one will focus more on the best interests of the child test under the new Divorce Act. And so my colleague will put a link in the chat here. If you want to sign up for part two, if you haven't already, you can do that on our website. We do also have a few other legal related webinars coming up this fall, one on legal bullying and another one on kind of navigating concurrent legal processes. So, if you have someone facing immigration and family law, maybe criminal processes, what that means. So yeah, I do encourage you to check out some of those other ones as well. And you can also access the recording of a webinar Pamela did with us last winter on the new Divorce Act. If you're looking for a little bit more after this one, that would be a great thing to check out. So without further ado, we'll get right into it. And I should say, for those who don't know, that Pamela Cross is the legal director at Luke's Place in Ontario. She is a feminist lawyer and a respected expert on violence against women and the law. So Pam, right before I pass it over to you, I'm going to launch our poll. And so for everyone here today, this is a chance for us to just get a sense of who's in the room, where you're joining us from, what your role is in the shelter or the transition house that you work at, and whether you've been finding that the new provisions in the Divorce Act have had an impact on the women using your shelter. So you can go through, give us your answers for those questions, hit submit, and once most people have answered, I'll share those results with everyone. So Most of you have moved through the poll there. I'll just give it another couple seconds. All right, so I'm going to end the poll and share those results with everyone. So we have a lot of folks from Ontario, Alberta, BC, some folks from Quebec. So welcome to everyone, Atlantic provinces, the territories. A lot of frontline staff here, which is wonderful. Some legal support workers and other folks. If you're one of the other category, feel free to let us know who you are in the chat, what you do. And it looks like a lot of you, there's some uncertainty about, whether the Divorce Act has had an impact. Other folks, about 28% saying, yes, it definitely has. So I will stop there and pass it over to you, Pam, to tell us a little bit more about the new Divorce Act.
Thank you very much, Leah, and welcome to all of you. Thank you for taking time out of your, I know, very busy days to spend an hour thinking about the Divorce Act. I'm really happy to be with you here today. I long for the day when we can be together in person again. Maybe it's coming, but meanwhile, thank goodness for Zoom. Let me acknowledge that I am on the land of the Huron-Wendat, Anishinaabeg, and Haudenosaunee peoples, known today as Kingston, Ontario. I'm a lawyer, so I always need to start with a disclaimer. This webinar is not to be interpreted as legal advice. It is legal information related to changes to Canada's Divorce Act that is accurate as of today's date, October 21st, 2021. So if you're someone who's going to go back and look at this webinar later, or a colleague of yours is going to look at it later, just be advised that laws change, how the courts interpret laws change. So if you're looking at this long after today's date, you need to satisfy yourself that the information is still accurate. I'd like to begin by telling you a little bit about Luke's Place and what we do there, so you understand the context and the perspective of what I'll be talking about with you today. And I should warn you, I've been giving webinars sort of constantly for the last 3 days, and my computer seems to have given up the ghost of cooperating when it comes to advancing slides. So if I jump back and forth a little bit, I apologize for that. At Luke's Place, we offer direct services to women in Durham region, which is just east of the Greater Toronto area in Ontario, who have left abusive relationships and are involved with the family court. We bring a team approach, a wraparound approach to this work, in which women work with both their own legal support worker, as well as pro bono lawyers who offer their time to us. Our LSW concept was the model on which the provincial government based its family court support worker program. And that program offers free family court support to survivors of family violence across Ontario. We also work at the provincial and national levels, engaging in research, writing, training, developing resources, and engaging in systemic advocacy. You can learn more about what we do by checking out our websites, which I don't seem to be able to show you here. I apologize for that. lukesplace.ca. And if you'd like to know more about my work, you can find that information at my website, pamelacross.ca. The focus of this webinar is on two aspects of post-separation parenting arrangements, both of which can be challenging for women who have left relationships with partners who abused them, and in many cases, whose partners continue to abuse them. How decision-making works, and what a woman needs to do if she wishes or needs to move with her kids. We'll be looking at these issues with an intersectional feminist lens, through the revisions to the Divorce Act, as well as looking at how this all plays out in the family violence context. The concerns and challenges for women who have left relationships where there was abuse are quite different from those of women whose partners treat them with respect. I'm also going to refer to some court decisions that have been made since the revised Divorce Act came into effect in March of 2021. I should also just say that many of you will live in provinces or territories where the provincial legislation reflects many of the same concepts that are contained in the Divorce Act. In Canada, family law operates on two levels. There's a federal law, the Divorce Act, and then there's provincial and territorial law. In fact, most family laws are provincial and territorial. The Divorce Act is the only federal law that deals with family breakdown, and it applies to everyone in Canada who's legally married and who's seeking a divorce. Everybody else has to rely on the legislation in the province or territory where they live. Those laws are not always the same as the Divorce Act. And to do your jobs, especially if you're frontline workers, assisting women or counseling or supporting women who are involved with family court, you should have some familiarity with both the Divorce Act and the relevant provincial and territorial legislation. First, and likely of most importance to the work that all of us do, the Divorce Act now contains a definition of family violence that's broad and inclusive. And I'm just going to read it to you, even though you can also see it on the slide. The Divorce Act says that family violence includes any conduct, whether or not that conduct constitutes a criminal offense, by a family member towards another family member that is violent or threatening, or that constitutes a pattern of coercive and controlling behavior, or that causes that other family member to fear for their own safety or the safety of another person. And in the case of a child, the direct or indirect exposure to such conduct. The legislation goes on to say that that abusive behavior, that family violence, includes physical abuse, such as forced confinement, but excluding anything someone does in self-defense, sexual abuse, threats to kill or cause bodily harm to any person, harassment, including stalking, the failure to provide the necessaries of life, psychological and financial abuse, threats to kill or harm an animal or damage property, as well as the actual killing or harming of an animal or actual damaging of property. So we finally have a meaningful, substantive definition of family violence that makes it clear it doesn't have to be criminal, there don't have to be criminal charges, and it's not just physical. This is going to be very helpful. The other big change to the Divorce Act has been the addition of 11 criteria to frame out the best interests of the child test. Courts are always required to apply what's called the best interests of the child test when they're making decisions relating to kids. But until now, the Divorce Act didn't say what that test consisted of. There are now 11 criteria. Judges must require all of them. And one of them is the presence of family violence. Another big change to the Divorce Act is that the language has been revised. We don't talk about custody and access anymore, although we actually still do because we keep forgetting and going back to the old language. But the new language is parenting time and decision-making responsibility. So no more custody and access orders, parenting orders that set out the time that each parent spends with the child and who's responsible for making decisions about what. Let's start by looking at decision-making responsibility for children. The parent who has decision-making responsibility, or the parents, if it's a shared responsibility, has the authority to make the significant decisions about the child's life and well-being, including decisions related to 4 major areas of a child's life: health, education, and this is a big one, but it's all one: culture, language, religion, and spirituality, and significant extracurricular activities. So it's kind of like there's 4 pillars of categories, and whoever has that legal authority to make those decisions gets to make the decisions in all of those areas. And as all of you, I'm sure, already realize, making a decision about one pillar in a child's life is going to have an impact on decisions in other pillars. Really, all of those blend together. As I said, this responsibility can be given to one parent or shared between the two of them. There are and will be challenges in situations that involve family violence with this idea that the decision-making can be shared, particularly because the Divorce Act also sets out that whichever parent the child is with at a given time has the authority to make decisions during that time. So let's think about this a little bit. in the context of an abusive relationship. Certainly, it's the intention that those decisions, the decisions the parent gets to make just because the kids are with that parent, should be related to the situation at hand. So let's say that Leah and I have 3 children. We've separated. I'm an abuser. Leah has primary decision-making responsibility. The kids are with me for my parenting time on a weekend. And I'm not going to call her up and say, can I give them chicken noodle soup or tomato soup, right? I get to make those decisions. Likewise, if while the children are with me, there's an accident and one of them requires medical care, I'm going to let her know. But meanwhile, I'm going to get the child to the hospital and make sure that whatever the crisis is being dealt with. So it makes sense. The parent who the kids are with should get to deal with the situations that are at hand and any emergencies that may arise. But the language is not as clear as it could and should be. And we have to look at it through the lens of an abuser. The abuser's goal in the family, now that the parents have separated, really is not about what's best for the children. It's about maintaining power and control over the former partner. That means this language creates an opening for him to interpret almost any decision as one he can make when they are with him. For instance, let's say that Leah has enrolled the children in swimming lessons that take place on Saturday mornings, and the kids are with me every other weekend. I just decide, hey, they're with me. I get to make decisions. We're not going to swimming lessons. It's not particularly because I don't think they should go to swimming lessons. I'm making that decision because I know it's going to get under Leah's skin. And more importantly, it's going to send her the message that I'm still running the family. I'm still in charge. I'm still in control. It could also mean that I decide not to give the child medication that Leah and the pediatrician have decided a child needs. It can come up in countless ways. So that's one challenge with the way this provision in the Revised Divorce Act has been written. The other challenge is that judges continue to make shared decision-making orders, just as they used to make joint or shared custody orders. And this is almost never in the best interests of children, because the father's motivation is usually to maintain power and control over the mother. It's not because he has a genuine interest in being involved in making decisions that are good for the children. There are a few cases that have grappled with this issue since the Revised Divorce Act came into effect. We're providing case citations for you there in the slide, 3 cases. I'm not going to go through each of those cases in detail, but I am going to summarize some of the key points that they made. Family violence, in particular spousal violence, might mean the victim is unable to co-parent due to trauma, and cooperative arrangements might lead to further opportunities for violence. So this is a very important and positive direction to see the cases moving in, because we know that this is true, but judges haven't always seemed to respond to that. If we're starting to see decisions where judges are saying, look, it's unrealistic for a victim of family violence to be expected to co-parent with the abuser, and if they're also saying that so-called cooperative arrangements for parenting are actually going to lead to opportunities for further abuse, that's a good step in the right direction. Unfortunately, one of these cases also sets out that fleeing to a women's shelter itself is not necessarily proof of family violence. I find this really disturbing. I'm sure all of you do as well, because you all work in shelters. We know that women who show up at the doors of our shelters are not lying to us. We know that they're there because they need somewhere safe. And it's really disturbing to me that a judge, she actually, and it is a female judge in this case, goes further and suggests that possibly the move to the shelter was an attempt on the mother's part to create the impression that there had been family violence. So very troubling to read that decision. More positively, a couple of these cases say that the courts can apply a broad definition of family violence when they're making parenting decisions, making parenting orders. So in other words, the courts are saying, yeah, we like this definition that's in the new legislation or the revised legislation, and we accept that family violence has to be understood and applied in a very broad and inclusive way. There's one case that I want to look at in particular, in addition to the three that are listed on the previous slide. In this case, the court gave the mother sole decision-making responsibility or authority over all aspects of the children's lives, and in doing so took a number of factors into account. The judge in that decision said that shared decision-making should not be ordered where there's poor communication and where the parties fundamentally disagree on many issues. What we've seen in the past in too many cases is judges saying, I'm going to make an order for shared or joint custody because these parents need to learn how to communicate. But in the Brown case, the judge says, I'm not ordering it because there's no history of good communication. This isn't the time for people to start to learn how to communicate effectively with each other. The judge went on to note that the inability to have good communication is a risk factor for conflict, which is then a risk factor for the children. So drawing a straight line between what puts the mother at risk and what's harmful for the children. She said that joint decision-making requires a basic level of respect and civility, not something you see very often in an abusive partner, by each parent toward the other, and that the required level of communication cannot happen in, and this is her quote, in an environment of verbal abuse or intimidation. What happens is that the views of the bullying parent prevail, whether or not they are in the child's best interests. No parent should be expected to subject himself or herself to the bullying of a former spouse. I think this is pretty strong language. I'm excited by this decision. It's about communication. The judge isn't saying anything about the fact, there should be or there doesn't need to be physical violence. I'm really happy to see a move away from that. And the fact that the judge seems to understand that poor communication itself can be a form of intimidation is a really important step forward. I think we can continue to see very different interpretations of this definition of family violence as it applies to decision-making authority or decision-making responsibility over the next several months or even couple of years. Things in law move really slowly. And so the fact that this law has been in effect since March of this year, maybe to you that seems like a long time. To lawyers and judges, it's like it's barely out the front door. It's going to be some time before all of the lawyers and judges get well enough educated about what these changes to the legislation mean. And then we'll start to see some precedents being set. But in terms of decision making, at least, I think we're off to a good start in terms of a number of decisions that we've seen in the last 6 months. I just shared 4 of them with you. 1 not so great, 3 pretty good. So that's a good beginning. So Leah, are there any questions in the chat or the Q&A at this point that are relevant to this?
No, there aren't any at this point. So just a reminder to folks to put those questions in, and you can put them in English or French, whatever folks prefer. So go ahead.
The other topic that we're going to cover today is relocation or moving with children. We're not really looking at the issue of child abduction, although if people have questions about that, and if we have time, I'm happy to try to answer those questions. What we're going to look at is the issue of relocation or moving in the context of a legal move where one of the parents doesn't want to live where they've been living before. It's certainly not uncommon for a woman to want to move or to need to move after she's left a relationship in which her partner abused her. Women have very personal reasons for wanting to move after separating, but there are some common themes. She may have a job offer in another community that's better than any opportunities where she is now. She may have been transferred by her employer, or she might have lost her job. If she's entered a new relationship with someone who lives in another part of the province or country, she may want to move to continue that relationship. Perhaps her parents are aging and she wants or needs to live closer to them so she can provide them with assistance and support. Most importantly, a woman who's left an abusive partner may need to move for safety reasons, to be somewhere that he can't have access to her, he can't stalk her, harass her, or to be closer to support from her family. The Divorce Act governs the movement of children and contains very specific provisions about what parents need to do if they want to move with or without their kids. The legal requirements vary depending on a number of factors. The impact the move will have on the time the children spend with the other parent, how much time that parent spends with the children, the ages of the kids, how close the children are to each parent, and the reasons of the parent who's moving for making the move. So all of those become part of the consideration of the court. But of course, it's law, so it's not simple or straightforward. It's not just about moving. In fact, there are two different kinds of moving with children. One is called a change of residence. This is a move that will not have a major impact on the child's relationship with the other parent. So most often this would be a move within the same city or a reasonably small geographic area. If I can move from one neighborhood to another, or if I want to move from one neighborhood to another, that's probably not really going to affect the parenting time that my kids spend with their other parent. Even if I want to move from one small town to another, maybe now it's a half-hour drive instead of a 15-minute drive to get the kids back and forth, that's not going to be seen as something that's having a major impact on the child's relationship with the other parent. A relocation, on the other hand, is a move that will require a significant change to the existing parenting schedule. This is generally a move of some distance. It could be to another province, even another country. In some cases, it could be a move within a large city. Let's say, for example, the children are really young and transportation is a challenge for the family. Neither parent has a car. The existing parenting schedule gives both parents frequent parenting time. That move, even if it's within the city, may be seen as a relocation as opposed to a change of residence, because now the parent who wants to move is creating a situation in which getting the children back and forth between the two homes is a significant challenge. If a mother has parental responsibility for her children and wants to move without them, now this is almost never going to happen. If I have the primary parenting time with my kids, I'm not likely to want to move without them, but the law covers this nonetheless. So I'll just comment on it briefly. So I decide I'm going to move, but I'm not taking the children with me. I have to still notify the other parent and make any necessary adjustments to the parenting schedule that my move requires. But the other parent doesn't have to consent. The same is true in the reverse. Let's say the other parent, who is not the primary parent, wants to move or plans to move without the children. So the kids live with me. My ex decides to move from the city where we've been living to another province. He's got a better job there. He can do that, of course, but he is expected to give me notice. And if anything needs to be adjusted in the parenting schedule, it's up to him to initiate that and to make that happen so it's not inconvenient for the children or for me. So if he's moving to another province, obviously adjustments to the parenting schedule are going to be required. If he's been seeing the kids every week, that's not going to happen now. So what's he going to suggest as an alternative? Is he going to suggest some Skype time or Zoom time? Is he going to travel back once a month and spend a longer chunk of time with the kids less frequently? The person who's moving in that situation has to do all the work of figuring out how the parenting schedule is going to work. But I don't have to consent. He can move. I don't have to consent, but I also don't have to consent to any parenting arrangement that he suggests to me. It's got to be reasonable. And if it's not reasonable, I get to say no, and then he's got to figure out how he's going to deal with that. So that's if a parent is moving without their children. And I only mention it because in the past, there was never any obligation on the parent who was moving to do anything. But now there are responsibilities. They have to give notice. More interesting are situations, of course, where it's the parent with the children who wants to move. If the mother wishes to move with the children and the move is a change in residence, so a move that will not have a significant impact on the children's relationship with their other parent. She still has to let the other parent know, and she should try to minimize inconvenience for the children and the other parent. But the other parent does not have to consent. So we'll go back to the idea that the kids and I are going to move from one neighborhood in the city where we live and where my ex-partner also lives to another neighborhood in the same city. I have to provide my ex with notice before I move. I have to say, hey, we're moving in a month. Here's the new address. It's going to be a little more complicated to get the kids back and forth. Here's my proposal for how we make that work. But I don't need his consent in order to move. It's assumed that the move is insignificant enough in distance that we can basically figure out a way to carry on. The real challenge comes if I'm going to make a move that is a relocation. And as you'll remember from what I said a few minutes ago, a relocation is a move that will have an impact on the time the children spend with the other parent. So here the notice requirements are more onerous because of that. The Divorce Act in section 16(9) says that the mother, well, whichever parent is moving with the children, but we're going to assume it's the mother, must complete the required notice form and serve it on her partner at least 60 days before the planned move. We've given you a link to the forms, both for the person who's initiating the move and for the person who might be responding to the notice of relocation. So I fill in the required notice form. I serve it on my former partner at least 60 days before the planned move. I'm sure you can already start to see where there are some problems with this. If my former partner agrees or just ignores the notice and doesn't object, then we can move on the date that I set out in the notice of relocation form. If, however, my ex does not agree, they can formally object within 30 days of being served. So let's say I serve on November the 1st. I want to move on January the 1st. That's actually 61 days, but let's keep it easy. If my partner's going to object, they have to do that by December the 1st. And they have to fill in this object form. So both the notice and the objection have to be done with the proper paperwork. And as I say, we've given you the link to both of those forms. They have to set out in their objection to relocation form why they're objecting to the move, as well as any objectives or objections they have to the mother's proposed new parenting arrangement. So let's do this by way of an example. And Leah, you're going to be my unfortunate former partner here. So I'm the abuser. Leah's the loveliest person in the world. We have two kids who are 8 and 10 years old. Well, let's say we live in Kingston, that's where I live. And the children have been spending time with me, no longer called Access. They've been spending parenting time with me one evening a week after school till bedtime, and every other weekend from Friday to Monday. But Leah has only been able to get a part-time job in Kingston, and she now has a full-time job offer in Ottawa. She has to let me know 60 days before she plans to move that she's going to move. She has to tell me why, and she has to offer a proposal for a new parenting arrangement. Now, this could be a problem for a number of reasons. First, her job may start in less than 60 days. She's got to move, get settled, get the kids in school, and so on. There are safety issues, and we'll talk about those later because they're actually dealt with separately in the legislation. So she sends me the notice, and I think, well, no way. You're not taking my kids away from me because I'm an abuser. So that's what I think, right? It's all about me. So then I have to serve her with my objection to relocation form within 30 days of getting the notice. And in there, I have to say why I'm objecting. So obviously, I'm going to say I'm objecting because I'm used to seeing my children every week, and that's not going to happen if they live in Ottawa and I live in Kingston. Leah has put forward a new plan that the kids would spend 3-day weekends with me every 3 weeks instead of a 2-day weekend every 2 weeks, and that I can have Zoom time with them twice a week instead of an in-person visit once a week. It's probably not quite as great for the father anyway. It might be fine with the children, but it's reasonable given the ages of the kids. They're 8 and 10. They're old enough to go on Zoom. And given the fact that they're going to be living at two hours away from where I live. I mean, I'm not a judge. I'm not saying that that would be sufficient to satisfy the judge, but I think it sounds like a reasonable place to start. But the abuser, of course, because what he wants to do is maintain his power and control, is probably just going to automatically reject that not unreasonable proposal. And if that happens, then it has to go to court. And so what the court now has in front of it, a number of documents. First of all, they can go back and look at the original file from when Leah and I went to court to sort out the parenting arrangement. So they'll see any evidence that Leah or I introduced at that time. They'll see that the judge who handled the case at that time decided that Leah should be the primary parent, that she has sole decision making. And if there's any unsavory information about me in there, the judge will be aware of that as well. In addition, the judge is going to look at both Leah's notice, which will include where she wants to move, why, and her proposed new arrangement for the children, and my objection, which will include my reasons for objecting and whether or not I like the proposed plan for the kids. And now the court has to decide. How? Well, it starts by applying the best interest of the child test. Then it will also look at this long list of other factors that you can see on the slide. It will look at the reason for the relocation. Leah's got a good reason here. She hasn't been able to become full-time employed in Kingston. She's got a full-time job offer in her field in Ottawa. That's a good reason to move. Court also looks at the impact on the children. There's no doubt that there will be an impact. They're going to have to start at new schools. They're going to have to make new friends. But let's say, all of Leah's extended family lives in Ottawa, so they're not going to be moving to a place where they don't know anybody. Did Leah give the required notice? Yes, she did. Is the proposed new parenting arrangement reasonable? Well, I just made one up a couple minutes ago. I think it is reasonable, so let's say yes, it is. Have both parties up till this date complied with the existing parenting order? Well, maybe I've been a real slacker and I've missed a lot of my contact time, my parenting time with the children. Leah needs to put that evidence into her court case so that the judge can think, well, it's great that Pam's hollering about her parenting time now, but over the past year, she missed half of the parenting time visits that she had or could have had with the children. Does the existing parenting agreement or parenting order stipulate a geographic area in which the children must live? This is something for women to consider at the early stages of their case. Do they want that parenting order to say neither parent can remove the children more than 60 kilometers from whatever city they're living in now? It might sound good at the time. It could be problematic later if the woman herself needs to move. And then the court also looks at how much time the other parent has spent with the kids. So that's me. How much time have I actually spent with them? And what's my general level of involvement with them? Do I show up for special events like soccer tournaments or school plays? That's what the court thinks about. Where's the burden of proof? So who has to persuade the court of what? As perhaps you already know, in family court, the standard of proof is what's called on a balance of probabilities. That means, again, to keep using Leah and me as an example, that the judge has to find that one of our stories is more credible, more believable than the story that the other one is bringing forward. Here, there's two different ways the court looks at this, depending on the history of the family. If both parents share roughly equal parenting time, so the kids are week on, week off, or 4-3-4-3, whatever, time with one another, it's the parent who wants to move who has to prove that the move is in the children's best interests. But if it's the parent who has the majority of parenting time who wants to move, the other parent has to prove the move is not in the children's best interest. Now, I got to tell you that I read this in the legislation about 20 times before I understood it. So let me go back to the example of Leah and me. So let's say that instead of the children living primarily with Leah, they were spending an equal amount of time with each of us. Leah still wants to move to Ottawa for this great new job. She has to persuade the court that that move is in the best interest of the children. Because right now, they're spending an equal amount of time with both of us. On the other hand, if we go back to the original scenario, the kids live with Leah, they see me every other weekend and briefly once during the week. I'm the one who has to prove that the move is not in their best interests. If a parenting order is already in place, and if the move is seen to be in the best interests of the children, the court will typically defer to the parent with primary decision-making responsibility. So here, there is a parenting order in place. The kids live with Leah. She has established to the court that the move is in their best interests. The court is pretty much always going to defer to her and say, yes, you can make the move. There is an exemption from the notice requirement when there are safety issues. And that's whether the woman is moving as a change in residence or as a relocation. She can avoid the 60-day notice period. Section 16.9 sub 3 of the Divorce Act permits a party to apply to the court for an exemption from the 60-day notice period. The former partner would not know about this application until it's over. The person seeking the exemption must prove that notice would result in a significant risk of violence. So I'm a really awful abuser. I have continued to be highly abusive to Leah, even after we separated, even after we had a parenting order in place. I've been charged criminally a couple of times. I've frequently threatened her. My most common threat is to say something like, I'm the one who's still in charge of this family. You don't get to make decisions that I don't agree with. Of course, she's not going to want to give me 60 days notice that she's planning to move. What am I going to do? There's every reason to think that she would be at risk of harm. She also probably doesn't want to give me her address in Ottawa or her proposed address. So this section of the Divorce Act allows her to bring what's called an ex parte application to the court. I don't know she's planning to move. I don't know that she's applied to the court for an exemption from the notice period. She is given that exemption, she moves, and then we sort things out from there. But at least she's been able to make the move. She's now in a different city. And she's, I think, to some extent, safer from me. Before I go on, because I want to talk a bit about what your role can be to support women who are dealing either with decision-making issues or moving issues, I'm going to stop because I do see there's something in the Q&A. Is there a question there, Leah?
Yeah, and I think you've answered this in a way. It came in a little bit before the most recent slide, someone asking whether the woman needs to give her new address to the abuser when there are safety concerns. So I don't know if there's, oh, and a second one here, so I'll give it to you at the same time, around how difficult is it for people to get those exemptions from the 16-day notice?
I'll answer the second question first. It's too early to know the answer to that. Isn't that a great answer? Because this new law has only been in effect since March. I scan the laws or the court decisions pretty consistently, and I haven't seen a decision about that. Now, that could just mean it's a decision that didn't get reported in one of the law journals. But I think a year from now is when we can do some really meaningful research to see how the new legislation or the revisions to the legislation are being interpreted. So I can't really answer that question. In terms of the address, it's true that when somebody applies under this section of the Divorce Act for an exemption from the notice period, they don't have to provide their address at that point. If the woman also doesn't want to ever have to give her address, she's going to have to make that argument. I think this would be the place to start to make it. So back to Leah and me, even though we still live in the same city, perhaps she already has obtained an order that she doesn't have to provide her address to me. Then she would be arguing when she makes her application for an exemption from the notice period that she should never have to provide her new address, similar to the fact that she doesn't have to provide it now. But I don't think that's a guarantee. Really, this is to let the person move before the other person knows that they're going to move and before they know where they're moving to. But it isn't necessarily a permanent protection from having to provide information about the new address. Anything else in there?
No, not at the moment.
Great. So let's look at this in terms of the roles that you may play in supporting women. And this, I'm going to look at both of the aspects that I've talked about, decision-making or mobility. You can provide valuable assistance to women by helping them gather evidence to support their case. This evidence will need to include details of past and ongoing family violence. And I would stress ongoing. Obviously, the history of what happened while the people were together is extremely important, but judges and courts need to hear that that violence often continues post-separation and need to hear what it looks like and how it impacts the woman and the children. So that would include things like historic and or current threats to harm the woman or the children, or to take the children and not return them. Somebody who's made threats to take the kids and not bring them back should not be involved in a shared decision-making regime, for sure. Past and or ongoing stalking, threats, and intimidation, whether that's in person or online. Ongoing coercive controlling behaviors, so that could include everything from online harassment, stalking for sure, gaslighting, psychological abuse, financial control, any of those kinds of behaviors, especially if they're a pattern, if that pattern's escalating, and if those behaviors cause fear. Information about any criminal charges, restraining or protection orders, or bail or probation conditions. Efforts to use the children to spy on or harass the mother. A summary of the history of parenting responsibilities. Who does the school call when the child is sick or needs to come home? Who's responsible for supervising homework, taking kids to the doctor or the dentist? Who's in charge or who has been in charge of extracurricular activities? How is parenting time allocated and spent now? All of that is relevant to both decision-making and mobility. Has the other parent tried to use the children to spy on the mother or to harass her? So is there any evidence that he has installed spyware on the kid's iPad, or has sent the children home with questions to pepper the mother with about what she's doing with her time and so on? How much has the family violence affected the children? And in particular, for a woman who's wanting to move, is the relocation going to be safer for her and for the children? If the woman is seeking sole decision-making, sorry, I've done one of those weird little glitches. If the woman is seeking sole decision-making, she needs to help the judge understand why shared decision-making would not be in the best interest of the children or safe for her. If she wants to move, she has to explain why the move is in the best interest of the kids. Some of the good reasons for moving would be a firm job offer elsewhere and no employment where she lives now, because that new job offer will provide financial security for her and the kids, better housing, possibly health benefits, enough money for extracurricular activities, and so on. And she needs to spell all of that out. She has to assume the judge knows nothing and build up from there. Another reason for moving might be family support, both practical and emotional. Maybe she's going to share a house with her sister. Maybe her parents are going to provide before and after school care. Emotional care is less tangible, but it's still something to be talked about. Does she have more ties to another community than the community where they currently live? For example, maybe the family lived in Ottawa for 15 years and moved to Toronto only 2 months before the parents separated. The kids haven't really gotten involved in the Toronto community yet. They haven't started school there. They don't have extracurricular activities. The mother doesn't have any social or family connections there. That might be a reason that would be strong enough to allow her to move. And then safety reasons, as we've talked about already. Is it safer for her to move because the abuser can't drive past her house frequently, can't interfere with her moving around the city, can't show up where she works, show up where she shops, and so on? The court will also want to know, in the event of a relocation, what steps the mother plans to take to minimize the impact of the move on the children. Can she keep them involved in similar extracurricular activities? Can the move take place in the summer or at least in the winter break so the kids aren't in school in one city on a Friday and in another city on Monday? How will she help the children stay connected with friends in the old community? She should provide a proposed new parenting arrangement that does not unduly reduce the other parent's time with the kids. For instance, depending on the ages of the children and the amount of time the other parent currently spends with them, the mother could suggest things like sharing the costs of the children's travel. If the kids are old enough to be put on the bus or the train, can the parents split that cost? Is she willing to accept a reduced level of child support to reflect the traveling costs that the other parent is going to incur to come to the new location and spend time with the children there? Can they share transportation responsibilities? You know, if it's a 10-minute drive between Leah's and my place, we can probably be pretty casual about that. It's not a huge inconvenience for either of us. But now that it's a 2-hour drive, are we going to share that responsibility? Am I going to drive them one way and she's going to drive them the other? Or are we going to both drive halfway and meet somewhere in the middle? Could the new parenting arrangement mean that even if the time is less frequent, it's longer? And can there be more online or telephone time? A new relationship on its own is unlikely to be persuasive evidence that the move is in the best interests of the children, unless it's a stable, ongoing situation and the new partner is involved in a positive way with the kids. If Leah wants to move to Ottawa because she's dated somebody a couple times and that's where they live, it's not going to fly. There's no indication yet that that's going to be a long-term relationship. That person doesn't really have a meaningful relationship with the children and so on. There is a recent case, there's two actually, that I'm going to talk about briefly here, that explores this thoroughly. In this case, the mother of two children wished to move with them from Ontario to Washington State to join her husband, with whom she had recently had a baby. The other parent of the kids opposed the move. Until this point, the mother's husband had been able to conduct his work from the children's habitual residence in Ontario, but that was pre-pandemic. And during the pandemic, his visa in Canada expired and he had to return to Washington. So they'd been able to make it work without the mother having to relocate because the husband didn't have children in Washington State and he had been able to work in a distanced setting, but that came to an end. And by this time, the mother and her new husband had had a child. So the other parent opposed that move, but the trial judge, based on the evidence that the parents presented and a report from the Office of the Children's Lawyer, supported the mother's request to relocate, noting that she had a practical and realistic plan to maintain the children's relationship with their other parent, and that her plans were child-focused. This mother also made it clear to the court that even if she wasn't given permission to move the children, that she herself would be moving. And I think that had a big impact on the judge's decision here. He also found that there was no suggestion that the mother's decision to move was to improperly deprive the other parent of time with the kids. And that case was upheld by the Court of Appeal. So that seems to be a pretty solid decision. One more that I'll mention just briefly, because I would like to leave a couple of minutes for wrap-up questions if there are any. And this is a more dramatic move. A family living in Ontario, mother, father, and a daughter who was 10. The mother had an opportunity to teach in Dubai for 11 months, and she wanted to move with the daughter from Ontario to Dubai. The father argued against the relocation. He said that the distance, obviously considerable, would affect his relationship with his daughter. He also had concerns about how COVID-19 was being managed in Dubai, and further noted that Dubai is a part of the United Arab Emirates, which has not signed the Hague Convention. So he would have no remedy if the child were not to return to Ontario, which is a very legitimate concern. The mother had decision-making responsibility for the child as well as primary care, pursuant to an agreement the parents had signed 4 years before. Justice Williams in this case reviewed the legislative provisions in detail, so it's an interesting case to read for that reason alone, and we've given you the citation there. She also considered past case law, and she made a temporary order allowing the short-term relocation of the child. She thought the move was in the child's best interest based on all the evidence, talked about the opportunities for the child to live in a different culture, so on and so forth. Her decision also included consideration of the child's wishes. The child very much wanted to go to Dubai. The academic and social benefits to the child, the cultural opportunities the relocation would provide, and the ability for the daughter to remain connected with the father through video conferencing. Her order also set out an arrangement for in-person visits in Dubai if the father were to travel there. This was a family where there was a fair bit of money, so it certainly isn't impossible to think that the father could have traveled to Dubai once, twice, or even more times during the 11 months that the mother and daughter would be there. So those are a couple of decisions about moving with children. I gave you a couple of decisions that dealt with decision-making issues. I hope that's all helpful. This brings us to the end of the, of the webinar. I do think we have a few minutes for questions.
Yes.
And I believe also you're going to send the slides out to people so they can refresh their memory that way, right?
Yes, I will send the slides and the recording in case people want to go through it again or take notes or anything. We do have a question here. So someone asking, what about the father speaking negatively about the mother, brainwashing the child? Does the court consider that as abuse toward the child?
It absolutely should. Yes. So the way family violence is defined in the legislation, that big definition we looked at, and then all of the different kinds of behaviors as well as the factors, absolutely that kind of intentional attempting to turn the child against the other parent would be seen as a form of family violence and would be seen not to be in the best interest of the child.
Great. And maybe we can sneak in one last one here. So how long does it generally take to get a decision from a judge, like for these moves, if it's time sensitive?
Judges are aware of time sensitive issues. So let's say that I make an application to the court to move with my kids, and I make the application in April, and I need to be in the new home by September. I mean, it doesn't hurt to give lots of notice to the court if you can, and if it's safe to do that. Then the court might take a little bit of time. But if I come to the court and say, I've just received this fantastic job offer and I really have to start in 2 months, the court will be sensitive to that to the extent that it can.
All right. Well, that was perfect timing. That was our last question. So I just wanted to say thank you so much, Pam, for that really informative, helpful presentation. And thanks to everyone who's put in those wonderful questions, to the interpreter who's been helping out. When you leave this webinar, you will be taken to a feedback form. We really appreciate your feedback. It's super helpful for us in putting together these webinars. And just a last reminder as well to sign up for part 2, which will be happening in January, and for our other webinars that are upcoming. So thank you so much, Pam, for joining us.
It was my pleasure. Thanks, everybody.
Awesome. Thanks, everyone. Have a wonderful day.